565 Kentucky Oil Gas Conservation Commission. Okay, Kentucky Oil Gas Conservation Commission. They hereby decree of the Department of Natural Resources, the Kentucky Oil Gas Conservation Commission, composed of the 5 members, the 4 members of the members shall be appointed with the governor. 5 of the members shall serve as the chairman of the commission. The director of the division of oil and gas shall serve as the ex officio capacity non-voting member, except in the case of the tab. 4 members appointed with the governor shall be representative of the state with no more than one. They may be directly employed with the exploration, production of oil, gas deriving from 50% of the personal income of the exploration, production of oil, gas engaged with the business directly servicing, supplying with the activity. No member of the commission shall participate in the deliberation of the commission or a vote of any manner before the commission in which his or her employer, any of the business in which of the financial interested party, but a member of the commission not prohibited deliberating or voting matters of the general interest, fixing statewide spacing patterns affecting him and his or her employer, business unit, the financial interest of the member of the class of the person affected with administrative regulation order of the commission. Commission shall not contain more than one representative for one operator, including subsidiaries, affiliate, and 4 members appointed with the governor. 2 shall be resident of Eastern Kentucky. 2 shall be resident of the Western Kentucky. Longitude 84 degrees 30 minutes shall be deemed the division line between East Kentucky and West Kentucky. Member of the commission, except the chairman, shall be appointed with the terms of 4 years. For the except that the original appointment shall be before for terms of 1, 2, 3, and 4 years respectively. Of the members of the after July 15th, 1998, 1 member appointed with the fill the term expiring June 21st, 1990 shall serve until the January 21st, 2001. Of the members appointed with the file the term expiration of June 21st, 2000 serve until January 21st, 2001. 1 member should be filed with the 1 and the other 2 with the terms expiring January 21st, 2001 shall serve until the January 21st, 2001 until the 1 member to fill with the second of the 2 terms expiring with the 21st of 2001 shall serve until January 21st, 2003. Subsequent appointment shall be before the 4-year terms ending on the January 21st. Each member appointed with the governor shall serve until the successor is appointed. Qualified members reappointed with the governor serve the successive terms. Members reappointed with the governor have served successive terms. The member of the commission before performing any duty or there hereunder with the oath shall be certified officer and administered. The oath with the writing and certificate shall be filed with the office of the secretary of state. The vacancy of the members appointed with the governor shall be filled with the appointment by him for unexpected term of the members of the whose office shall be vacant from the appointment shall be named with the governor within 60 days of the occurrence of the vacancy. With a member appointed with the governor may be removed with the governor in case of the incompetent neglect of the duty, grossly immortality, maleficency of the office. The commission shall meet at times. The place shall be designated with the chairman. The chairman shall call the meeting of the commission anytime they shall call the meeting of the commission. Written request to the member the notification each of the meetings shall be given in writing of each of the member by the chairman at least 5 days in advance of the meeting. Any 3 members of the one of the which may with the chairman constitute with the quorum of the transaction of the base member, including holding the hearings of the majority of the commission present of the required to determine an issue brought before the decision. Each member of the commission, except for the chairman, receive with $150 per diem, to not exceed with 100 days per calendar year, which actually engage in performance of the duties of a member of the commission. Each member of the commission, including the chairman, shall also be reimbursed reasonable and necessary expense for the actual incurred performances due to the member of the commission. The commission shall execute and carry out the administrative enforcement of the 353, 65, 651, 652. Commission make investigation record and facility deemed proper. If the emergency is found with the exhibit of the commission with which and judgment required with the making the change of the renewal of the extension of the administrative of the regulation or the first of having hearing an emergency regulation made to be promulgated in accordance with the KRS 13A with the emergency order with the issue in accordance with the KRS 13B 125. Commission have specific authority to promulgate the enforceable responsible administrative of the regulation issue order responsible and necessary to prevent waste, protect the correlated rights governing with the practice procedure for the commission or other administrative Provisions 651 and 652 issue the subpoena with the attendant with the witness and subpoena with the duty for the detective of the production any of the books, record of the maps, chaps, and other of the diagram, other pertinent documents, administrative of the oath of affirmation witness with the judgment of the commission necessary to do so for the effect of the discharge of the duty provision in 353, 651, 652. Any interested person may have the commission call the hearing with the purpose of the taking action respectfully any of the matter jurisdiction of the commission by the request of the therefore writing upon receipt of any of the request. Commission promptly shall have the hearing thereon. After the hearing, with all of the convenience fee within an event, with 30 days after the conclusion of the hearing, shall take an appropriate action regarding the subject matter thereof that may be deemed appropriate. If the hearing injunctionary in nature, it shall be conducted in accordance with KRS Chapter 13B. Agreements made in the interest of the conservation of oil and gas, or both, or the preventive ways between the among owners and operators, or both owning separate holdings in the same field of the pool, any year of the period of the geological other data underlay with the accumulation of oil and gas, or both, with agreements between and among these owners and operators, or both the royalty owners, for the purpose of bringing the development and operating a field pool area to any other part thereof. The unit establishing, carrying out the plan and cooperative the development and operation thereof. When the agreements are approved by the Commission and hereby authorized, shall not be held with the construe to violate the laws of the state relating to the trust and monopoly contract combinations restraining the trade. Nothing in this section shall be construed to give the Commission right of the authority to supersede with the authority of the Department of Administration, KRS 353060. Alright, 353-570, permanent required the department may authorize the operation prior to the issuing of permit. No person shall drill the deep in a well with a drill with a stratospheric test well with a reopen and plug with a well with the production of oil and gas for the injecting water, gas out of the fluid in an oil gas producing formation except for the seismograph test holes after June 16, 1960. Drilling a deepening water supply after June 16, 1966 until the trust of the person permit with the department except for the provided with the 353-588. When the application of the permit required with the section complied with the provision of the chapter rules regulation promulgated to hearing with the department shall issue the permit. The department may authorize commencement of the drilling, the deepening, with the reopening of the well prior to the issuing of the permit thereof, except for the location well known underlay with the coal bearing strata. The consent with the owner and operator leaser with the coal bearing strata has been not granted. Consent is implemented with the coal bearing strata of the zone of the oil gas leaser unless the coal is not under the lease of any third party. Alright, 353-572, eligibility requirements of the permit issuances of under the chapter of the when operator ineligible to receive the permit, the successor operator factors consider the energy environmental cabinet to promulgate administrative the regulation relating with compliance eligibility requirement, restoration eligibility applicant operator and control person of the cabinet shall not issue the permit approve the application transfer of the well by the success of the operator pursuant to the 353-590-23. An operator shall not be eligible to receive any permits but become the successor operator under the chapter applicant falsified otherwise misrepresented the information on the relating permit application failed to obey reach an agreement with the cabinet regarding unappealed violation 353-500 through 720 administrative regulation promulgated here on the control of the applicant, forfeiture of the bond, applicant control of any and other operator with the forfeiture of the bond and control person, applicant serve the control person for other operator when unresolved the bond forfeiture occurred, application his or her control of the control of the or in control by another operator with the forfeiture of the bond. Cabinet may promulgate administrative the regulation law with the proper administration complying with the review described in the section. Cabinet shall restrict the application of the operators and control person of the deemed with a permanent eligible to pursue it. Subsection 1A section submission applicant correcting the false misrepresented information with the cabinet restrict the eligible applicant operator control person necessary to deem permit eligible to pursue it. Subsection 1B section of the satisfactory abatement violation included the payment of a civil penalty. The cabinet shall restrict the eligibility applicant operator control measure for the deemed permit and eligible to pursue in subsection 1C and 5 and the section entry for the satisfaction complying with agreed order between the operator and cabinet with the result of the operator's outstanding violation required by the payment of a civil penalty provides restitution cabinet any of the costs associated with the forfeiture, plugging, property, or abandonment over the well except the bonded amount. Alright, 353-575, the duty application made with the confer of the permit of the drilling in which to strip of the permitted area, the prior to issuing of the permit to drill of the oil and gas well on the land permitted with the bond and provision of KRS Chapter 350. The applicant shall certify he has met with the confer with offered and met confer with the permit as activity will disturb in the permitted area. Expiration permits. Each date is each permit issued on the 353-500 through 720 shall expire 1 year after the date of issue, but unless the drill on a deep to reopen well with commenced pursuant to their prior with the expiration 1 year period. However, the permit shall extend by 1 year if the prior expiration date permit applicant notice for the department in writing. Applicant requires for the extension of the notice of the operator with the record coal leases and licenses, mine license originally entitled to receive the copy of the plat KRS 350-050 was remember the affidavit stating the information original permit application correct for the submitted fee with extent of the amount equal to the permit fee required by 352-590 with the requirement of permits to issue prior with July 15, 2002 with no extension of the grant with any purpose can be complete survey and severance for the ownership of the oil and gas ownership of the surface distributed and left for the request extension of the agree with the writing of the surface owner extension of the permit of the term permanent pursuant to subsection 1 shall not be decreed with the right of the objective well located under 353.060 in order to mediation 353.5.901. All permits issued with the department and previous today with it shall continue with the written with only in the drill well has been commenced pursuant thereto before 60 days after June 16, 1960. Investigation of an abandoned wells application report and bond. Any person may investigate abandoned well until upon receipt with approval of the department. The person shall submit with the department an application requesting with approval of the investigation date with the plan with the method of the investigation. All of the case of the pay has been completed. Surveillance of the ownership of the oil and gas ownership of the service distributed with the application shall include plans to prevent erosion and sediment and $25 fee. Certification by the applications of the authority to enter for the property and problem of the wells located to conduct the investigation. The department shall review the application investigation. The department approve the request investigation. The applicant shall be allowed to produce the well without permit as required in 353.570. The applicant shall submit the report of investigation to the department in a form provided by the department in order to produce the well within more than 60 days. The applicant must obtain with the bond required in 353.597 in order to qualify the notwithstanding the provisions of 353.592. No fee shall be required for any such well. Part 590, application permit fees, plat, plugging, restoration bond, blanket bonds, corporate guarantee, use of forfeited funds, oil and gas, well plug fund, well closure, occur, orders, requirements for permitted stratigraphic test wells not included in water supply well review under KRS 353.700. Any person seeking permit of the 570 shall submit with the department a written application which covers the department of a person at 18 years old shall not be eligible to permit issued under the Chapter E application shall be accompanied with its fee as follows. Fees shall be $300 for each of the well double the deep to reopen the pursuant of the relay with the production, repressuring the storage of oil and gas for each water and supply well with the observation well with the geological structural test hole. If the department receives the delegation of authority with the Minister of the Underground Injection Control Program within Section 1425 of the Safe of the Drinking Water Act, the department may with the administrator of the regulation establish fee for the schedule of fee with the amount not to exceed $50 per well. In addition to the fees imposed with the paragraph of the A with the subsection upon each application for the drilling with the deepening reopening well for the purpose of relating with the production, repressuring the storage of oil and gas for each water supply well with the observation well with the geological structural test well with the fee schedule with the fee with the yourself with administrative regulations shall not exceed the amount sufficient to recover the costs incurred with the department administrative of the Underground Injection Control Program, less than any other state federal funds which are made available for the purpose of all of the money paid by the state treasurer for the fees required on paragraph B with the subsection of the shall be and sold with youth for the department administrative of the Underground Injection Control Program under section 1425 of the Safe Drinking Water Act, Public Law 93-523 as amended. Applicant each of the deep wells shall be yourself the fee with according with the following: schedule of the vertical deep well with a total vertical deep at the 7,000 feet or left fees should be $500. Total vertical deep greater depth greater than 7,000 feet with a fee should be $600. Horizontal deep well total measure of the depth over the 10,000 feet or left shall be $5,000. Total measured well depth over the 10,000 feet or greater than 10,000 feet, $6,000, and $500 for each additional lateral horizontal deep well. Each of the additional deep horizontal well located in the well pad shall be assessed the following fee: $3,000 total measure with a depth up to 10,000 feet, with $4,000 for the total measure with a depth greater than 10,000 feet. All money with a chain with the license for the fee required within Kentucky shall be sole purpose of the department shall be given addition of the monies appropriate to General Assembly given to the department. Each application in court and accompanied by the pledge shall be the location and elevation each of the prepared according to the Ministry of the Regulation promulgated 507-20 with the plat certified accurate with the correct with the professor, land surveyor, license according with the provision of KRS Chapter 322. With any person with a department application for the permit of the drill of the shell well, reopen the well with the temporary abandonment with the well with the not with the cover of the charity with the develop bond. The department shall be except for the providing section of cover the shell well operator posting of the bond with the well permit the issue on the June 27th, 2009. The department shall require the $2 over the bond amount with every foot of 2 vertical well depth. The application transfer the file with the after June 27th, 2019 pursuant to subsection 23 of the section bond and shall be the $2 every foot with the 2 vertical well depth. That shall be posted for the transfer operator failed both of the required bond shall result in an order of the issue of the department required with the proper plugging the abandonment of shallow well and the wells or refusing transfer request of shallow well or wells Plugging and reclamation bond with a vertical deep well shall with $25,000 for however the commission of the may shall with a higher amount with a vertical deep well with the anticipated plugging and reclamation costs exceed the minimum bond amounts established in the section. Minimum amount with the plugging and the reclamation bond with a horizontal deep well with a shall with $40,000. However the commission may establish a bond amount greater than $40,000 with the anticipated plugging and reclamation cost with the minimum bond. 10A. All bonds required posted June 27, 2009 under this section plugging wells shall be made in the favor of the department be conditioned well with the pond with abandonment shall be plugged with the coin with the ministry of the regulation of the department. Then all the records of the department of the fields are specified. Remaining effect of the plugging of the well approved with the department over the bond release and forfeit of the department. All bonds required for the post of the June 27, 2009 under the section plugging well shall be made with the favor of the department be conditioned the well with the pond abandonment being plugged distributed over the area of the reclaimed over the coin of the applicable statute of the ministry of the regulation propagated to here on the all and all record with the required of the department and filed with the specified. Remaining in effect with the plugging of the well of the reclamation of the distributed to the area of the approved of the department over the bond relief and forfeited by the department. All bonds to be posted in section plugging deep wells shall be made in favor of the department to be conditioned over the wells upon with the abandonment to be plugged with the distributed to the area of the reclaimed in accordance with the statute of the ministry of the regulation of the department. That all records by the department filed with the be specified with the rain in effect with the plugging of the well reclamation and the distributed to the area of the approved of the department and bond with all of the department. Operator may petition for the department to amend with the drilling depth of the bond with the amount with the applicable to the particular well shall not proceed with the drill with the depth of the grave within the authorized of the department and with the operator authorized except for the pursuing the ministry of the regulation promulgated by the department. 12A. Any shallow well blanket filled with the operator with the June 27, 2019 shall remain in effect with the plugging and transfer of the well secured with the blanket bond with the blanket bond relief of the forfeited by the department and event with the number of well with the plug and transfer the bond with the result of the operator with the be eligible blanket bond with the lower of the amount with the department shall relief the bond and lower amount based upon the tiered structure. This is time over the bond was issued after 27, 2009 event with the operator shall with the shallow well blanket bond that was filed prior to the June 27, 2019 drill acquire the distant well his remaining capacity of the blanket bond after June 27, 2009. Operator may secure the such well with existing blanket bond limited over the bond. However, the number of wells eligible to covered by the blanket bond filed prior to June 27, 2019 with a tariff of more than 500 wells should be limited to 1,000 wells. After June 27, 2019, shallow well operator only with an individual bond may file with the department blanket bond according to the following tiered structure. One of the 25 wells required with a $25,000, 26 of the 100 wells additional $30,000 bond, one of 100 wells to 500 wells with additional with a $150,000 bond, 501 to 1,000 wells requiring an additional $100,000 bond. After 27 2009, well operators have more wells that can be accompanied with a blanket bond instructions for the establishment paragraph B subsection either pursuant with the paragraph A subsection lieu and individual bonds. Incremental amounts of the blanket bonds filed with the department according with the tariffs established paragraph B subsection. Nothing contains in subsection will occur with the well operated blanket bond existing for the June 27, 2009. Increase the amount of the blanket bond well covered with existing blanket bond. If the operator corporate subsidiary operator further shall provide with a corporate guarantee with a guarantee with the parent corporation operator wells covered under this bond cooperative guarantee provided the operator failed to perform proper plugging and abandonment with any well covered blanket bond with a guarantee shall provide with the alternate financial assurance corporate a corporate guarantee shall remain in force until the guarantee of the notice of the cancellation certified mail with the operator to the department certified cancellation not occur however during one of the 120-day period with the first day of the both of the operator the department have notice have received the notice of cancellation other than the certified mail receipt. Operator shall not be eligible to file a new blanket bond additional well with the existing blanket bond operator the outstanding unabated violation care Kentucky regulations 353 and the adopted pursuant to which for the not appealed. Forfeiture bond with an individual bond portion of the blanket bond, any permit with the or operative with may be the with agreed upon with the department plugging the property abandonment over the wells forfeit with the permits or permits upon with the bond portion of the bond has been forfeited. The proceed of the forfeiture has been spent with the department of the plug reclaiming well of the wells unless the operator have the rest of the department all costs associated with the forfeiture plugging and proper abandonment. Any deep well operator only with an individual bond might file with the department blanket bond according with 1 to 10 with the deep vertical deep wells $200,000, 1 to 10 horizontal deep wells according with $320,000 bond deposit when the cash in the bank is issued with a recoverable letter with the credit manager with the lieu with either with the individual well with the blanket individual individual acquiring a single well of the domestic with a combination bond in which consists of the cash bond amount with the $1,000 over the posted lien property to cover the further plugging costs. $100 over the combination bond may be posted by each individual. Certificate of deposit of the principal of the pledge, the lieu of the bond with the interest of the payable to the making of the pledge may serve for an individual well bond. Certificate of the deposit of the principal which is pledged in lieu of the bond whose interest of the payable the party making the pledge may serve the blanket bond provided for $1,000 of the blanket bond spoke for the department in cash. Bonds and bonds refer to the section of the execute with the well operative with the principal surety bond with the corporate surety authorized to do business in the Commonwealth. The 20 a deposit shall serve the in lieu of the either both of the bonds all the cash bonds cover the department deposit the interest bearing account with the interest of their bond payable to special agencies account known as the oil and gas well pluggings created subsection 27 of the section to be within forms proposed to describe in all cash bonds being held by the department by July 13, 1990 should be likewise deposited interest-bearing account with the proceeded for the purpose of establishing an oil and gas well plugging fund. The amounts prescribed in subsection 7 of the section shall be applicable to only permits after June 27, 2019. All bonds of the permits issued prior to June 27, 2019 shall remain in full force except for the duration of the permits to secure bond. 22 of the blanket amounts prescribed in subsection 12 of the section shall be effective June 27, 2019. Operator having the blanket bond with the department of June 27, 2019. Event with the capacity of the bond reach with the discretion increase the level of the blanket bond incrementally. Increase the blanket bond amount with the individual bond prescribed in subsection 12 of the section of the wells drilled in subsequent to June 27, 2019. Drilled the blanket bond has received less necessary to perform the tariffs prescribed in subsection 12 of the section 23A prior to commencement of the operation. Wells operated in the name of the different operator well operators become a successor operator shall file the application transfer the wells executed both of the current operator application paid for the $50 of the well the department post appropriate bond. B1 upon receipt of the request of the well record report may be the operator seek with becoming the successor operator approve of the current of the operator the department shall print the well record with the report with the records requested provided the report both of the current operator with the operator seek with the become successor operator if the report indicated the existing outstanding violation of the missing record of the well file with the pursuant of the chapter with any of the application transfer of the wells filed within 30 days of the day of the well report with the successor operator with the decline with the recept transfer any wells outstanding with the violation or with the missing record with the may agree with the accept of the responsible abatement of the violation following the missing record based upon the successor operator responsible with the well record report with the subject of the bond requirement of provision of 353-572 with the department shall approve of the transfer for the requested wells any portion thereof the not declined successor operator. The department may not hold the successor operator responsible liable for missing record with the not disclosed the well record report provided with the department prior to transfer with the missing records that were not filed completed by a previous operator for which the information errors are complete with the records not visibly available, reasonably available. Or subject to KRS 352-572 with upon written approval to require the transfer of the successor operator with assuming the obligation chapter of the particular well of the wells relieve of the current operator responsible again with the chapter of the well of the well transfer shall be with the reasonable of the current operator with the transfer of the successor operator has complied with the requirements subsection and before relinquishing operation successor operator before relief of the responsibility under the chapter agreement with the current operator with the current operator shall remain responsible the bond does not relieve of any of the wells without outstanding violation missing records which the successor operator declined to accept the transfer 24 if the requirement selection respect to any of the provisions 353 500 720 735 or 735 to 747 and any administrative of the regulation over the promulgated issue that complied with this time and the limits of the department of the administrative regulation by this chapter of the department should notice for the non-compliance to be served by the operator a certified mail address for the permanent address shown in the application for the permit the notice shall specify the respect of the operator has failed to comply with the written administrative of the regulations of the department if within 45 days after the mailing of the notice for the non-compliance, no agreement has reached with the department regarding the legislature to comply with the director to determine the operator has complied with the requirements set forth with the department of the bond shall be the order of the forfeited with the department of the forfeit order that shall become in effect for 30 days for the department give the operator notice of the order unless the petition has been filed with the 2 KRS 353-700 in which case the forfeited order shall become effective upon with the final determination secretary affirmation forfeiture order following the conclusion of the petition process of petition and the notice of compliance for the issue pursuant to section 24 of the section of the cabinet may issue the well closure order to any person operator where one oil gas well in the violation of 353-500 to 720 and 735 to 747 and any administrative regulation and or promulgated issue they are under violation could cause with a reasonably expected cause of imminent threat of the human health and safety of the environment the operation of oil gas well of the person without first posting the bond well closure order affixed with the red tag mark with the wellhead later violation copy of well closure order mailed with address of the record per reasonable person or operator with if an address on file within the division labor violation, well closure, or to notify the person operator to immediately receive the operator of the well, abate the violation of 353, 500, 720, or 735 to 747 an administrative regulation order promulgated to issue thereunder. Any person operating well under circumstances described in the area A2 the subsequent must be ordered properly plugged and abandoned well. Such order does not relieve any prior obligation owned with the current operator with a record of KRS 353-180 with a well closure order with the appeal with the KRS 353-700 written 30 days on issue with a bond forfeited pursuant to the provision of the chapter made collected with the attorney of the Department of the Attorney General after notice of the director. All sum of the receipt of the forfeit bond shall be placed in the state of the treasurer of the special agency account with the designated oil and gas well plug fund, which shall be the interest-bearing account with the interest thereupon paid for the funds available to the department, and shall be the expense of the plug and abandoned well coming with the authority of the department pursuant to the chapter. The plugging of the well pursuant with the subsection shall not be considered to relieve the operator any other person from civil or criminal liability would exist from plugging unencumbered and unexpected balances fund remaining in the beneficiary with the down lab for the carry forward for the purpose of fund until approved by the subsequent legislative action. Any permanent stratigraphic test well the subject of the requirements are under section of the KRS 353-590-1-550-610-660-14 static well test defined as KRS 353-510-14. So be plugged with 180 days of the completion of the drilling in the well. Stratigraphic test well permitted oil and gas production prior to producing oil and gas, deviating true vertical. Any stratigraphic test well converted with the oil and gas production under the paragraph B subsection requirement of the KRS 353-660 1 to 3. Purpose of the chapter water supply well does not include any potable water supply to domestic use of livestock, any water primarily cooling purpose of industrial process. Any order final determination department under this section shall be subject to the review in accordance with the KRS 353-700, any administrative regulation promulgated thereunder. Alright, and that was 353-590. 353-5901 Operators Reclamation Program Content Distribution Agreement and Mediation Report Reviews of 3 KRS 353-700. Well, operators shall submit the Department of Operation Reclamation Plan with the time of the filing application permit the drill with the deep and reopening of the well plan shall be filed with the form provided by the department shall include with the narrative description of the best management profit intended to be employed with to prevent pollution, erosion, sediment for the well site with the all the distributed with the area with included row of the distribution shall be adopted with the base management practice utilized the site differ from those of the described plan. The narrative description and location with all of the area distributed include location roads, gathering line well sites of the tanks and other storage facilities. Any information required by the department with the company narrative, the description plat depicting the location of the land of all the distribution facility. Additional information from the department may require the plan shall include a minimum narrative describing the following category: site plan construction practice of the reclamation method of the well completion, maintenance of the reclaimed site closure, describing plugging and abandonment reclamation program procedure of the department shall review and approve of the operation reclamation prior to the permit issue of the case is whether there has not been surveillance of the ownership of the oil and gas ownership of surface to be disturbed. In all cases there has been completely severance of the ownership of the oil and gas, the ownership of the surface and surface ownership of the disturbed the air of the assigned of the agreement of well operator arranging the operation reclamation plan. Time following the application, well operator shall cover the delivery of the surface operator of the distributed areas who have not agreed with the operation reclamation plan certified mail with a return receipt with requested. Copy of the operation reclamation plan requiring paragraph A with the subsection 1 of the section of the narrative description only of the disturbances of the plat requiring paragraph B in subsection 1 of this section. Notice to read, if you do not agree with the proposed of your land with the well by the well operator may request the mediation with the distributed energy of the environment cabinet office of the ministry of the hearings. If the meditation is requested and you decide to participate, each part of the meditation will charge $100 to help cover the cost of the meditation. You will be notified of the time and the place of the meditation. If the well operator chooses the meditation over your rights to participate, certified mail receipt with a return shall be filed with the well operator with the department made by the permit application. If the well operator has unable to reach agreement with the surface owner owner of the area of the distributed in all cases have the complete variance for the ownership of the oil and gas, for the ownership of the traverse distributed with the permit required with the chapter not issued for the dispute with the referred and mediation of the continuity conducted by the Energy Environmental Cabinet's Office of the Ministry of the hearing meditation have to conclude with either by the agreement between the parties report with the mediator in accordance with the subsection 6 of this section. Well operator may request mediation anytime of the filing of the permit with the application. All of the permits participating with the meditation shall be non-refundable fee of the $100 with the Kentucky State Treasurer, which shall be the sole use of the Department additional on the aid of the money appropriated with the general sum of you of the Department. The Department may waive the mediation fee for the surface owners who submit with a verifiable to prove the financial inability to pay. The Department shall notify the well operator all surface owners area with the distributed drilling well have not agreed with the operation and reclamation plan with the time, date, and time of the mediation was conducted with a certified mail return with a receipt. The Department shall conduct with the mediation site proposed with the distribution 15 day with the date requested if the practicable at the mediator will attempt to facilitate an agreement between the well operator with the surface owner with the agreement with the forthcoming after mediation with the 5 day with the mediation issue the report with the director recommending the director. A. Accept the plan submitted with the well operator. Accept the plan modification set forth the mediator if the agreement between the well operator surface owners are all distributed with the forthcoming on the mediation. The mediator shall consider the following factor for the reasonable use of the surface well operator issuing the report of the director, location of the road, gathering lines, tank batteries, time of the operation, consider all season use of the land if the surface owner needed well operator direct expeditiously impact for the other use of the land and surface owners include with the location, timber, house, barns, bonds, crew, ops, other improvements, whether the plan include with the plan timely effect with the reclamation of the distributed areas, any other information deemed appropriate with the mediator director shall make the final agency determination within 5 days of the receipt of the meditation reporting except the plan submitted with the well operator accepting plan modification set forth with the mediator and approved over the plan containing elements of both original and modified plan in order of final determination of the department section shall be subject to the review in accordance with the 353-700 and Ministry of the regulation promulgated thereunder. We're going to cut the tape at purpose and applications.